Today I am going to start my video with a very of the important and simple the question about Article 32. What is know about the Article 32 and why it is important for us or we call any ordinary citizen of the state? That question is a not to be the to be an ordinary question, because that question is a highly important for those of the student who will be appearing and who has been the appearing for the civil services examination, as well as those student who are the student of the political science of the class 11th and the 12th. That question is a so the important, because that question to lay down the foundation of the political student, and that's to give to idea about what is to know about your the rights. Why we say that Article 32 is so important? Because the Article 32 is a talking about some protection. What is the protection? It's mean that if there is a clear violation of the fundamental rights, so what is there is any of the security, any kinds of the protections available in our the Constitution of India? Yes, because Article 32 is so important, because Article 32 is a heart and the soul of the Constitution of India, and that is the phrase had been used by the Dr. B.R. Ambedkar in the Constituent Assembly. Because if any ordinary citizen of any ordinary citizen or any individual feel that there is a clear clear violence there the fundamental right, or we call infringes there the fundamental rights, so what are the types of the protection that are the available? So ordinary citizen of the state, or we call the individual, they have the right to approach toward the court to protect their the infringement of their the fundamental rights. So that's why Dr. B.R. Ambedkar said it is a heart and the soul of the Constitution of India. The first question will be arise in your the mind. What is the writ? Because in the Article 32, Supreme Court has a power to issue a writs. The question is that what is a writ? Writ is nothing that it is the special law, or we call special order, that has been the issue or order by the Supreme Court as well as the High Court. So one question is that which of the authority has a power to issue an order regarding writs? The answer is that the authorities are Supreme Court as well as the High Court. Along with that, there is another of the question in sync with the writs. Which of the courts in India, specifically High Court and the Supreme Court, which of the court has the higher degree of the ambit in the regarding of the writ issues or orders? And you will be the observe that High Court has the higher degree of the ambit in the regarding of the writs, because High Court are not to only the concentration on the fundamental rights, but it also provides some of the legal rights within the writs jurisdiction. So that's why we call that the High Court has the higher degree of the area, or we call the ambit in the regarding of the issuing or order of the writs. So under the Article 32, Supreme Court issue an order in the regarding of the issue, and we have of 5 type of writs. We have 5 type of writs. First, habeas corpus. Second, mandamus, third prohibition, fourth quo warranto, and fifth one is a certiorari. First writ, habeas corpus. Habeas corpus means to provide body. In this of the writs, court order that an arrested person should be present before it. If the court observe, if the court and there the observation finding that the arrested person said to be the free when the law not to be the satisfactory. Mandamus means we command. Under the writ, court order to any legal officers to perform his and her the legal duty if infringing by any individual rights. I have the one of the simple example is that if you are going to any public office, or we call any authority, if the legal authority not to provide his and her the legal authority, that you have a right to approach toward the court and ask the court, please issue a order, or we call please issue a writ in the mandamus. Okay. A third one is that prohibition. In this of the writ issued by the higher courts, it's mean that higher courts means high court as well as the supreme court, to order for the lower courts for the jurisdiction. Fourth one is the quo warranto. In this of the writ under which any officer any office holder who are not the entitled to hold the office, is mean that if you are a person to hold any of office but you are not to the eligible to hold the position or to hold a office, that's why if any of the person approach toward the court and the court issue a order in the quo warranto. Fifth one is a certiorari. Certiorari is in this the writ, court order to the lower court in the matter of the transferring pending cases. And in this of the discussion, one of the important of the word is known as the locus standi, and that the locus standi means if any one person who are not directly engaged within the case, but their engagement is so important to protect their the lives or their the protection for the fundamental of the rights. That's why we call of the local standi. Local standi is the mean that in the first of the writ habeas corpus, it's mean that the person is detained by the unlawful by any of the law, but the person is not the applicable, but the person is not applicable because the person is the arrested in the jurisdiction of the police or any of the authority. So who has a authority to go to approach toward the court ki sir, that the person who are arrested is not to be the arrest position is not to be the correct. So the locus standi is so important, and try to keep it in your mind ki on which of the writs the locus standi is applicable or not. I'm just to give you the provide the locus standi is applicable only for which of applicable for the habeas corpus, prohibitions, quo warranto. Okay, the mandamus is a not. Thank you.